So for decades, Johnson & Johnson produced talcum powder. It's called Johnson & Johnson baby powder, for lack of a better word. And the talc is alleged to have asbestos in it. And the dermal application of that around the genital area, primarily in women, but also in men, leads to different kinds of cancers, ovarian cancer, mesothelioma, and the like. And so tens of thousands of people have filed claims against Johnson & Johnson. Johnson & Johnson did what's called the Texas two-step and put those claims into an entity called LTL Management Corporation, bankrupted it. It's presently in a bankruptcy proceeding in New Jersey, which I have very uneasy feelings about. But in any event, we've tried hard to negotiate a settlement for those people. There's a proposed settlement on the table for the amount of $8.9 billion. And we're going through the bankruptcy process to see whether that's going to be approved by the ladies who have to support it 75%, or there's no deal. People that are recently diagnosed with either mesothelioma or epithelial ovarian cancer, other gynecologic cancers, are eligible and will need to file their claim within 2 years of their diagnosis. It's a statutory procedure that the Texas legislature allowed. It's called a divisive merger statute, and it allows a company to, in effect, divide itself and put the liabilities and certain assets into one part of the company so that the other part of the company can maintain a thriving business without the overhang of the debt and the liabilities. It's a public policy choice that, in my view, is a very poor choice, but it's authorized. And so companies around the country, primarily in the asbestos context, do a divisive merger. They put the liabilities out in a small company. They bankrupt it, and then they allow it to go through the bankruptcy process to gain the surety that they don't believe that they have in the tort system. It's a very insidious procedure that should not be done very often. There's a lot of complaints about it. I get it. I've been one of the ones complaining about it. But in the situation where a company has liabilities with respect to cancer risk, where the latency is 30, 40 years, we've got to come up with a procedure, if not in the tort system, in some other system, to get these people paid, because companies are not going to pay billions of dollars to solve part of the problem. We've got to allow them to envelop the problem and extinguish all the liabilities at once. We'll leave that up to Congress about how to do that, but that's the fight. We've been doing mass torts for a quarter of a century now. We've had good fortune, won a lot of cases down at the courthouse, settled billions and billions and billions of dollars worth of recoveries for our clients. And people know who we are, the judges know who we are, and we try to do a good job. But that past success has allowed us access to resources that are, I don't want to say they're unlimited, but they're certainly unparalleled across this country. And we get to work on the cases that we want to work on. And that's what's really made me happy is that this law firm has been at the forefront of the most significant mass tort cases in this country's history over the last 25 years. You can't forget where you came from, and that is that even in a mass tort firm where you represent tens of thousands of people at once, those are tens of thousands of individuals. Each one has their own story, their own case, and it requires our care and our excellence to make sure that their case is treated as if it was the only one in the office.